The debt was transferred to plaintiff without saying from where and by whom. Where's the assignment? When you see that lousy complaint and you say, well, it's clear they have no proof, how does that get to where the poor defendant now has to defend themselves? If you can knock out any one of those 4 or more, you win the case automatically. They have to prove all 4 elements. This is what you do when you're faced with a creditor lawsuit. Hey, Brian Parker today, coming at you with another interesting video for you. This one is against a creditor lawsuit, one I haven't done before. It's the First National Bank of Omaha. And to give you a little background of that, the case here is a client that I represent, and it is what they say they got from Flagstar, and at the time, it was a couple of years ago, Elan Financial, which is US Bank, was doing the collecting, the servicing, and the ownership of the debt. Now suddenly FNBO shows up and says, you're getting sued, we own the debt. So we're gonna break down the lawsuit of FNBO today, piece by piece, so you can apply the knowledge and education today to your lawsuit, whether it's debt buyer or creditor, but this is skewed towards creditor lawsuits today. But check out what I do. It's what I do, and I hope it's the voodoo that you do, and let's see if this helps you. So, first of all, as I said, FNBO is suing my client, but my client says, this is a Flagstar bank account. I don't know who this FNBO is. So let's look at the Flagstar Bank's website, Shazam, and it says right there, what's happening to my Flagstar credit account? And Flagstar says, as of June 16, 2024, FNBO will begin managing the accounts for Flagstar credit card customers. Your account will now be an FNBO Flagstar Visa card. That's great, because now, hopefully as a disciple of our channel, you can already see the assignment and merger issues going on here. The second question they ask, will I have a new account number? Yes. Your account number, expiration date, and 3-digit security code will change. So that will be lovely facts for you. Why? Because the debt collector or the creditor, whoever's suing my client, is not going to take great care. They never do in their pleadings because of the 9 out of 10 rule, which says up to 9 out of 10 cases are going to get defaulted. Why put the effort in? So we take that apathy and we put it into our defense. Or in this case, I'm asking you again, should I file an answer or should I file a motion to dismiss? You'll tell me at the end. So let's look at the complaint, and that is going to be so helpful to us. Shazam. So that's the complaint from First National Bank of Omaha, who have attached nothing to this lawsuit to show they have in any way, shape, or form obtained the debt of my client. In fact, we'll break each paragraph down and you'll see what seemingly looks like a nothing complaint will give us a wealth of riches in our response. But first, a couple of commenters have made the comments after my videos, hey, why doesn't the judge just look at this and go, whoosh, out, whoosh? If you can see there's no case here, why doesn't the judge just on its own just say, bring me something that's real? Well, there are federal cases on this particular question. I'll give you one that I faced over the years, and I'll just, here, Shazam. That's Harvey versus Great Seneca Financial Corp, 453 Fed 3rd 324, 6th Circuit. I operate in the 6th Circuit and the 11th Circuit, but I also operate in other places, but that's the 6th Federal Circuit, 2006. And it stands for debt collectors need not have all the supporting documentation assembled before filing suit, as long as they we're depending on them to be reasonable, as long as they reasonably believe they can obtain it if needed and do so. So I've handled that issue before where it's just about every case, as you know, and that's why those commenters are asking, Your Honor, they never had the stuff. So, but there's a leeway there. Rule 11 is good and the bad. Federal law, Rule 11 sanction motions against attorneys, we all fear those, okay? So, and We shouldn't if we do a good job, but Rule 11 of the Federal Rules of Civil Procedure says does not require attorneys to ensure that their client can prove its case before filing. Instead, the rule mandates only that allegations and other factual contentions have evidentiary support, if specifically so identified, are likely to have evidentiary support after a reasonable opportunity for further investigation or discovery. So in the case of Harvey versus Great Seneca Financial, the court justified its holding that the debt collector doesn't have to really do a good job, if you will, by saying the defendant has the right to do discovery to point that stuff out, and then if it turns out they don't have the stuff, it behooves the debt collector to do the right thing, good luck, or the defendant can use the discovery of there not being the proper documentations in a summary judgment if it's federal, summary disposition, or federal, or a motion to dismiss if it's state, which I think puts too much burden on the defendant. There should be a better burden of proof, but I digress. So what are we going to do with that information? So when you see that lousy complaint and you say, well, it's clear they have no proof, how does that get to where the poor defendant now has to defend themselves? Well, there isn't a large standard for the debt collector to have to prove to get to court, but we can use their documents against them. That's my number one, it's probably a number 3 rule, but it's one of my number 1 rules, use their documents against them. So what you do is you take that complaint, let me just put it up there again, Shazam, and it is not titled, but it is clearly a breach of contract. And I'll show you why. Here are the elements for a breach of contract. Shazam, the existence of a valid contract, they alleging there's a valid contract. The plaintiff performed its obligations. They always will say, hey, we did the right thing. It's the other guy that's doing the wrong thing. The defendant's party failure to perform the breach, meaning they didn't pay or they did something wacky. And number 4, the damages suffered by plaintiff, the collector, as a direct result of the breach. Okay, so first of all, pro tip, if you can knock out any one of those 4 or more, you win the case automatically. They have to prove all 4 elements beyond what's called a preponderance of the evidence. That's what the burden of proof really is. The burden of proving your case isn't, you better have the right stuff. It's if you allege a claim, you have the burden of proving each element. Most debt collectors bring a breach of contract claim and an account stated claim, because an account stated claim has less of a burden and you don't always have to provide the contract. They've gone all in the wrong way here. So they've got a breach of contract claim and they've actually made their job harder. They did what they did. But again, this is what we do. We take advantage of the stuff that's in front of us. So we always look for the linchpin in the complaint. You know, I've got a couple of videos up there on the linchpin, looking for the linchpin. What, when you take it away, makes the whole complaint fall down? What I mean by that is, of the 4 elements, can you just knock out one? What's the linchpin? So here, we're gonna look at the lawsuit and how it's gonna help us. So let's look at paragraph 2, Shazam. Defendant entered into a contract with First National Bank of Omaha. The account loan number is, look at your language, and it was subsequently transferred to plaintiff. That's fantastic for us because they're already kind of wishy-washy on what the account number is. My client says, who the heck is FNBO? The Flagstar website says your numbers are gonna change, your account numbers are gonna change. Dollars to donuts, they don't have the right account number, we'll find out. And it was subsequently transferred to plaintiff. Whew. They've now admitted that they got it from somebody, but to whom? So we ask ourselves the following things. We say, hey, how come there's no contract attached? A breach of contract requires a contract. Make sure there's another right account number. We guaranteed this is the wrong one. Actually, even if it was the right one, the most recent one, it's the wrong one. My client signed up for an account stated, a credit card agreement that will have a different number, and that has to be taken care of in the chain of title. But the original contract, well, let me get to this. This will be good stuff. Subsequently transferred to plaintiff from where and by whom? Where is the assignment? The assignment, they are telling you, was transferred, so there's got to be documents proving that. Look at number 3 of their complaint. Plaintiff's the current owner of defendant's account. Okay, account, I thought this was a debt. So we ask, why is it referred to as an account if it is a debt? Does FNBO own the account or the debt? That affects standing. See how we're just tearing this apart with very little information? We're using their lack of information against them. Was the debt securitized so that only servicers of the debt and not owners? Meaning, is FNBO a servicer? Because they haven't said they own the debt, and if they are, they don't have standing to sue you. So let's look at 4, 5, and 6, Shazam. Again, we're looking, these are all linchpins. Defendant defaulted under the terms and conditions of the contract. Whammo. You cannot hold the terms and conditions breached or defaulted against someone without showing them. Think about how hard it is going to be for the subsequent owner to find the original signed contract of the defendant. I can tell you, it's not, almost 100% it's not going to happen, but if you're filing a breach of contract and you didn't do account stated claim would allow you to find a substitute, okay, of the contract. But then it'll have to be backed by an affidavit, and then you'll have a counter affidavit, so there's all these fun things you can do. 5, First National Bank of Omaha and or plaintiff, which one, completed performance under the terms and conditions of the contract. Let's read that again. First National Bank of Omaha and or plaintiff completed performance. You see how words are beautiful things? This is from First National Bank of Omaha, so it should say First National Bank of Omaha completed performance. First National Bank of Omaha and or plaintiff. They're already telling you in their words that there's more than one owner here. Isn't it a beautiful thing? Just got to read this stuff. As a result of the defendant's default, plaintiff claims breach of contract. Okay, which is it, the plaintiff or is it First National Bank of Omaha? But where's the contract? So we ask, where is the contract? Specific contract signed by the debtor whose terms and conditions plaintiff alleged were breached. That's a normal thing to ask. Which ones did I breach? No contract, no standing, no lawsuit. So all of the above goes into your counter affidavit, which I have attached to this video. And what I have attached to the video for you is a motion to dismiss in Word, I'll tell you why, an answer in Word, a counter affidavit against FNBO with, I added the securitization paperwork to the counter affidavit. It's all attached to the video for you. A letter to Flagstar in Elon Financial. Elon Financial and US Bank made a deal with Flagstar early on to put out these cards that my client signed up for. Where's the proof of transfer that the complaint specifically says to you in paragraph 2 happened? So we got a securitization letter to Flagstar, Elon Financial, US Bank, and FNBO, and a letter to Flagstar, Elon Financial asking for proof of the transfer. You have to ask for that stuff because you don't have it. And if they fail to give it to you, Your Honor, it seems to me they never had the right to sue me, therefore they haven't followed Harvey versus Great Seneca, and they can't have that immunity. See how that all works? So we have to, and you'll get my lovely show notes, of course. So we now look at putting all of that into the counter affidavit that's going to be attached to the video. So you've seen lots of my videos. Now what do we do? File an answer or a motion to dismiss? I'll give you 50 seconds. Of course, you file a motion to dismiss. It's a beautiful thing. They got a nothing, and we're going to show them everything that they don't have. So I'm going to attach to this motion, obviously, the actual motion to dismiss. You'll put in your state or court rules. I used a Michigan case, but it's schematically a good skeleton for you. You just add your facts and law. But let me just put up a little bit. Shazam. A, FNBO lacks standing, and I cite the court rule. And number 3, I left out the others. You can go to the Killdebt.com to see everything else. But paragraph 2 of the complaint specifically states the debt was transferred to plaintiff without saying from where and by whom. Where's the assignment? And then you put in the actual allegation. So you always have to support, which is more than they do, and courts recognize that. You can see the other parts. And then I say at B, complainant paragraph 6 shows no ownership of the debt. First National Bank of Omaha and or plaintiff completed performance under the terms of the contract. Defendant defaulted under the terms of contract, terms and conditions of the contract. You gotta have the contract. So I snarkily write in my motion, Shazam again, they did not write, and I go down a list, the owner of the debt, the owner of the receivable, the owner of the obligation, the assignee of the original creditor, holder of the written instrument, who is the creditor under TILA Regulation Z definitions. Those are all questions. You keep asking questions. You may get a motion to dismiss. I may get a motion to dismiss. But if I don't, what I will have is an alternative. I file with it, as you know. Here's all my do I answer or do I file a motion to dismiss video right there. And in that, I say you always file a motion for more definite statements. So if they, Parker, I'm not going to give you the motions this early, but I will make them. And you've given them all the documents that are missing. So the court's going to go, well, I'm not going to let someone completely win. It's the Solomon rule. They cut the baby in half. Parker, I will give you that they've got to give you all those documents that you show are missing. It's essentially the same thing that I've won the motion to dismiss based on lack of standing of documents, but some judges, they just have to cut the baby in half. But there's a failure to state a claim, MCR 2.116C8, just a couple. Plaintiff's complaint fails to state a claim upon which relief can be granted, and I say why. The complaint alleges a breach of contract account agreement, but fails to demonstrate that plaintiff owns the underlying debt based on plaintiff's own SEC filings, Form 10K. Flagstar and FNBO regularly securitize their debt, yada yada. It's attached to my counter affidavit. By the way, you know the great things we've done with Killdebt 2.0. We're going to add something else. We're going to put the 10K SEC filing website right on Killdebt.com. So you won't have to go hunting around for securitization anymore. We're going to put it on the website. It will be yours as a member, again, on top of everything else we give you, Killdebt.com. So we now have before us some great work. This is what you do when you're faced with a creditor lawsuit, one as lackluster and without any proof. You hit them using their lack of own documents against them and use their words against them. Use the documents against them, use the words against them. Like, love, and subscribe. I hope this is helpful to you in all your creditor lawsuits. It's great solutions for you when you're sitting there scratching your head. You know what's even better? Parker GPT does everything I just said at the click of a mouse. In these documents, my show notes will go into Parker GPT, as will the motion to dismiss, an answer, all those letters, the show notes, everything I just talked about to give you a winning case and beat back the bad guy debt collectors. Parker GPT does it all. Thank you.